Kanu'S rendition from Kenya in order, Justice Nyako rules. Welcome to the news and thank you for tuning in to listen. Mrs. Nyako held that rendition for the purpose of criminal investigation is allowed. Justice Binta Nyako of the Abuja Division of the Federal High Court on Friday ruled that a rendition of the leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi, was in order. Mrs. Nyako, in a ruling to the right suit filed by Mr. Kanu, held that rendition for the purpose of criminal investigation is allowed. The judge said Mr. Kanu was on bench warrant. The law allowed that anywhere he is cited, he can be arrested and be brought to face his trial. Rendition for the purpose of criminal investigation is allowed. In the defendant case, there is a bench warrant on the defendant, Kanu. Suffice to say, he is a fugitive before the court, she said. The judge who dismissed Mr. Kanu's move to challenge the terrorism charge upheld 7 counts of the fresh charge filed by the federal government against the IPOB leader. Mrs. Nyako said the federal government, through the Office of the Attorney General of the Federation, AGF, had been able to establish some allegations against Kanu on counts 1, 2, 3, 4, 5, 8, and 15. Count 1, 2, 3, 4, 5, 8, and 15 show some allegations. The court shall proceed to try the defendant Kanu on those counts, she ruled. After the review of the 15 counts, she held that about 8 of the counts appeared to be similar and did not disclose action. She therefore ordered that counts 6, 7, 9, 10, 11, 12, 13, and 14 should be struck out. Mrs. Nyako also ruled that the order prescribing IPOB as a terror group still subsisted until it was vacated, since the issue was still on appeal. She dismissed the argument of Michael Zekome, son, counsel for Kanu, that whether IPOB was a terrorist organization under the Nigerian law or not was still a subject of appeal. On Mr. Kanu's bail plea, the judge directed counsel to the parties to present the argument. Mr. Zekome therefore urged that his client had never flouted any of the bail conditions, but that Mr. Kanu only escaped for his dear life during an attack on his residence. Citing judicial authorities, he said that until the person is tried and convicted, he should be allowed to walk free. He said his client was still innocent until proven otherwise. I humbly urge my Lord to use her discretion to grant him bail subject to my Lord's condition, he said. But lawyer to the Attorney General of the Federation, Shuaibu Labara, disagreed with Ozekome, contending that Mr. Kanu had violated all the bail terms. He said because the IPOB leader jumped bail, that was why the court revoked his bail and ordered his arrest anywhere he was cited. Mr. Labara further argued that what should be the subject matter before the court was the issue of contempt charge against Kanu and was not bail application. My Lord granted him bail in 2017 on health grounds, but since then till date, no medical record was submitted to the court until he jumped bail. What we should be saying is contempt of court because he has frequently violated the orders of the court, he said. He urged the judge to be guided by her discretion vis-a-vis the circumstances of the case. The lawyer said in the alternative, Mrs. Nyako should make an order of accelerated hearing on the matter so that Mr. Kanu could know his fate one way or the other. The judge adjourned the matter until May 18th and May 26th for ruling on Mr. Kanu's bail application and for trial continuation. Speaking with reporters shortly after the proceeding, Mr. Zekome told journalists that the remaining 7 counts affirmed by the court would be challenged at the Court of Appeal. On January 19th, Mr. Kanu challenged the terrorism charge filed by the federal government against him, arguing that the amended 15-count charge preferred against him was unmeritorious and should be thrown out by the court. The IPOB leader, through his lawyer, Mr. Zekome, Thursday filed a 50 billion naira damages against the federal government and the Attorney General of the Federation over his alleged abduction in Kenya and continued detention. Mr. Kanu had requested 100 million as compensation for the cost of the action at the Federal High Court in Abuja in a suit marked FHC ABJ CX 22, dated March 7th. The applicant argued that his abduction and rendition to Nigeria without extradition proceeding to hearing in Kenya is a clear violation of Article 204 of the African Charter on Human and People's Rights Ratification and Enforcement Act, CAP A9 LFN 2004. He said it also violates Article Part 5A of the African Charter's principle and guidelines on human and people's right. So what they are trying to say now is that the way the man handled him is actually very correct. Is the way he was abducted was correct. Is the way he was chained to confined to a place is correct. Is that what they're trying to tell us? Is that what exactly they're trying to tell us? There is no rendition at all. He enters Kenya illegally because both his British and Nigerian passports were seized before he was granted bail. If Nyako was wrong, then Ozekome need to renounce his son Asap. Are you serious? Are you serious? The judge says since Mr. Kanu was on a bench warrant, the law allowed that anywhere he's cited, he can be arrested and be brought to face his trial. Someone should tell the judge that no one is against anybody arresting a man who has been declared wanted. But the international standard is when you find such a man in another country outside the jurisdiction, you need the help of the Interpol. The country where such man is residing has police stations. You're expected to approach the nearest police station in that country and seek for clearance first. When you are confirmed to be law enforcement agent from a sovereign nation, the police station in that land will assign some officers that will help you arrest this man. When you finally arrest this man, the next legal step is to take him to a competent court of jurisdiction in that country he is residing. Tell the court that this man is from your country and you want to take him home to face his charges. Anything outside this is pure kidnap. Lawyers are coming out to say. And the thing is, this man never even jumped bail. He never jumped bail at all. I don't know why the court is not seeing the fact that this particular man, after he was granted bail, was actually, his house was invaded. The invasion that brought the killing of, I think, his parents, both his parents. And that he had to even run and did not even come back to pay his last respect to his parents. Sincerely, I don't know what is going on. I don't know. I don't know. How is kidnapping Nnamdi Kanu from Kenya in order? My dear, I don't understand. If Fulani wife have spoken, please, if you have any chance to move out of this country, I beg, waste no time. This country has been compromised. You can say that again. On this note, we have come to the end of the news. We say thank you for tuning in to listen. Until I come your way next time, enjoy the rest of your day.